through this collegium system, you have these judges appointing judges, right? Do you have any other institution where people themselves appointing themselves? Do you have MLAs appointing MLAs? Do you have MPs appointing MPs? No, because of these two deviations in 73 and 77, coupled with these instances of mass transfer, Sarkari judges being appointed, they developed a mistrust between executive and judiciary, right? So judiciary fought for its independence and carved out institutional mechanism which secured it independence. So through these four judges cases, first, second, third and fourth, exclude this as of now, right, for this conclusion. So through these four judges cases, judiciary is going to do nothing. Judiciary is going to fight for its independence, and it is going to carve an institutional mechanism. And when I am saying institutional mechanism, I am talking about collegium system. Hello everyone. So after having completed this lengthy chapter on Parliament and Parliamentary Committee, now finally we are delving into Supreme Court, that is Union Judiciary. So if you look, this is the structure of Union government that has been mentioned in Part 5 of Indian Constitution. And mind you, I am telling Part 5 of Indian Constitution, not Part 5 of Lakshmikant. So this is Part 5 of Indian Constitution that deals with Union government, the structure that you can see. Let me remove this. So this Part 5 of Indian Constitution deals with Union government, that is spanning from Article 52 to Article 151. So out of this Union government, we already have done these things. So the first part of Union government is Union executive. So out of this Union executive, if you remember, we already have done President, Vice President, then Council of Minister. Out of Council of Minister, which does consist PM and Council of Minister, a chapter on Cabinet, right? So Prime Minister we already have done. Attorney General, as far as concerned, will do when we'll cover the constitutional bodies. Then conduct of business we already have done. So Union executive has largely been done. As far as Union legislature, so from Union legislature it means Parliament. So Parliament also we have covered. Ordinance making power of the President, that is in third chapter of Part 5, we already have done. Thereafter, now we are in Union Judiciary, and as far as CAG is concerned, CAG also will do when we will be dealing with this constitutional bodies, right? So the Union government will be over as soon we have attempted this Supreme Court, that is Union Judiciary. So that was about Part 5 of Indian Constitution. Let us delve into next slide and let us see what is the scope of this particular video. As far as this chapter Supreme Court is concerned, so all of the chapter will be covered in 3 to 4 video, and it will entail around 5 to 6 hours. So you'll have to be patient. So in Parliament we had covered around 10 hours, right? This chapter is also equally important, right? And this will entail at least 5 hours. So rest assured we'll complete this, but you'll have to be little patient, right? So as far as this chapter is concerned, this is the scope of this video. So in this video we'll cover genesis and role of Supreme Court, right? How did Supreme Court came into existence? We'll trace historical roots of the Supreme Court, and then role of the Supreme Court, evolution of appointment process. So at this area, let's see, as far as appointment is concerned, right? Appointment of Prime Minister, appointment of President, all these things we had done within 2 minutes, or that is the time that we have allocated, 2 minutes or 3 minutes. But as far as appointment process of judges are concerned, especially Supreme Court judges, right? This process has gone through evolution, right? Earlier appointment process of judges was mentioned in Article 124. Thereafter some evolution happened, and we today have something called Collegium system. So how this Collegium system, which was not mentioned in the Constitution, and rather not even today it is mentioned in the Constitution, right? So how this came into existence, right? So there have been many cases, that is called first judges cases, second judges cases, third judges cases, right? Initially you had appointment of Supreme Court judges and High Court judges happening from Article 120, whatever process that has been mentioned in Article 124. So initially those judges were being appointed following the method mentioned in Article 124. Thereafter the intervention happened and you had this first judge's case. Then came second judge's case in 1993, and this year is going to be, mind you, very landmark year in judicial history of India, because from this second judge's case you will see that the collegium system is going to emerge, and appointment that was until now, until 1993, which was happening by the process that has been mentioned in Article 124, will start happening from this collegium system. Thereafter you had third judge case in 1998. It expanded the size of collegium again, and in the final leg of this video we'll do some MCQ. So that is the scope of this video, appointment process. When we'll discuss, right, we'll discuss the phases of appointment, right, and it is here that we are going to spend considerable amount of time, because, and here one more important thing, NJAC, National Judicial Appointment Commission, right, that as well we'll cover, that how this body came into existence only for few months, right, and this body went this way. Body was declared unconstitutional by judiciary itself, right, without even a single meeting, right. So this as well we'll discuss, and that is the reason then why this video is going to be very lengthy with only one topic, that is appointment process. So I hope you would have understood. Let us move to the next slide and let us start discussing this genesis and role of Supreme Court. So if I talk about the genesis of Supreme Court, genesis of Supreme Court can be, historical genesis can be traced from Regulating Act of 1773, the first act that was released by British government to control, to regulate the affairs of the company. So this was the first act in that direction in 1773. So although the genesis can be traced from Regulating Act 1773, but this Supreme Court came into existence in 1774 and not in 1773. But the problem with the Supreme Court that was established from this Regulating Act 1773 was that the jurisdiction of the Supreme Court was limited. It was limited only till Calcutta, right, and as far as other jurisdiction was concerned, means who these this Supreme Court will govern. So the governance or the jurisdiction of this Supreme Court was limited only for the British people, right, British natives rather, right. If you have any idea on the Regulating Act of 1773, you would notice these two things, these two key points. Thereafter come 1861, and you will see that various high courts were established in India through Indian High Court Act 1861, right. So you had establishment of High Court at Chennai, you had establishment of High Court at Bombay, right. So you will see in 1861 High Court at many cities will be established, right. Then come Government of India Act 1935, and there was establishment of Federal Court, and mind you, I am using the word Federal Court, not Supreme Court, right. So Government of India Act 1935, the court, the apex court, that was rather, it was not even apex court, this Federal Court that was envisioned by this Government of India Act, that was not even apex court. I'll let you know the difference between why I am not referring this Federal Court as apex court, right. And it was established, the Federal Court that was envisioned in this Government of India Act 1935, that was finally came into existence in 1937, right. And this is not an apex court, the reason being because the Supreme Court that you see today, right, it is a final body. Whatever cases that reaches to the Supreme Court, right, you cannot appeal, you cannot, there is no any court above this Supreme Court, right. So you have these subordinate courts, just a moment, you have these subordinate courts, right. Thereafter you have these high courts in the state, thereafter Supreme Court. So you do have certain grievances against the decision of subordinate court, you go to the high court, you have certain grievances against the decisions of the high court, thereafter you go to the Supreme Court. But above this Supreme Court there is no separate body who could hear against the decision of the, although there are a mechanism like curative petition and review petition, but those can be filed against Supreme Court decision as well, right? Only Supreme Court will look into their own decision by this method of review petition or by method of this curative petition, right? There is no appellate authority above this Supreme Court, but that was not case in this federal court that was envisioned by Government of India Act 1935, right? There was a body called British Privy Council, right, that was existing in Britain, right? And whenever any petition had to be filed or any complaint had to be filed against the decision of the federal court, it could go to this British Privy Council, and that's why I told that this federal court is not the apex court, right? Apex body is this British Privy Council, and that's why this federal court cannot be described as Supreme Court. Mind you, this dictionary is supreme, right? Finally, the Supreme Court of India, independent India, came into existence on 28th of January 1950 and not 26th of January 1950. So 2 days after the full operationalization of our Indian Constitution, 2 days after, so our Constitution was fully operationalized on 26th January 1950, and the Supreme Court came into existence 2 days after the full operationalization of Indian Constitution, establishment of Supreme Court. So this was about genesis of Supreme Court. If you want to see the constitutional roots of Supreme Court in Indian Constitution, so it is Article 124, right? So Union Judiciary in Part 5 of Indian Constitution has been dealt from Article 124 to Article 147. So these are the articles that has been dedicated to the Union Judiciary or Supreme Court. So the structure, the function, the role, the powers, right, all has been mentioned in Indian Constitution in all these articles. So the first article, that is Article 1 to 24, that does have mention of Supreme Court. So the first article reads, there shall be Supreme Court of India. Okay, so it is recognizing the existence of Supreme Court. There shall be a Supreme Court of India constituting a Chief Justice. Okay, so in the first article, Chief Justice, and until Parliament by law prescribes a larger number, until Parliament by law prescribes a larger number of not more than 7 other judges. Means what it is essentially saying, that unless Parliament by a law increases the number, right? So the numbers at that moment, means in 1950, was envisioned as 1 plus 7. So 1 Chief Justice and 7 other judges until Parliament by law prescribes a larger number, right? Today what do you have? Numbers are 1 plus 33, because in 2019 we had this act, Supreme Court Number of Judges Amendment Act 2019, by which 10%, means earlier you had this 30 judges, 1 plus 30, and when I am saying 1 plus 30, 1 CGI, Chief Justice of India, and 30 other judges, 10% increment happened by the Supreme Court Number of Judges Amendment Act 2019, and today number of judges in Supreme Court that stand today is 34, 1 plus 33, right? So Parliament by law has prescribed. So one question, one learning here could be that if the question is asked that who is the authority who can increase the number of judges in the Supreme Court, so it is not the President, right? So there can be a trap that the number of judges can be increased by President. No, it will be increased by Parliament, and it's not that Parliament will arbitrarily increase this. They will have to bring a law, and so you do have this law in 2019 that is called Supreme Court Number of Judges Amendment Act 2019, right? Mind you one thing, that even in today, means even in Constitution, even today, right, the number of judges is this 1 plus 7, right? The number of judges in Constitution, that is in Article 124, has not been changed, right? So right now you have these 34 judges including Chief Justice of India, but in Constitution you have this one mention of this 1 plus 7. The reason being that Parliament, while increasing the number of judges, need not to amend the Constitution. They just have to bring a separate law, and that will be all, right? While one thing means for the increasing number of judges, they need not to change the constitution. But if you have to increase the power of the judges, if you have to interfere, means Supreme Court if has to expand the power of the judges, if it has to increase the functions of the judges, if you have to Parliament has to do any other thing in relation to the power and function, in that circumstances, Parliament will have to amend the constitution, right? For change in number of judges, constitutional amendment is not required, right? And that's why constitution even today does have that number, because constitutional amendment has not been done, right? However, for change in method of appointment or power function of courts, right, constitutional amendment is required. So you will see that when method of appointment will be changed in 2014, and when you will see that a body called National Judicial Appointment Commission will be brought, which will change the method of appointment. So method of appointment until 2014 was by Collegium, and when it was supposed to be, when it was envisioned to be changed by NJAC, by the Parliament, right, you will see that we will bring up 99th Amendment Act, right? So this is what it is telling, that for change in number of judges, constitutional amendment is not required. However, for change in method of appointment or power or functions of courts, right, constitutional amendment is required, right? I hope these points you will have understood. Let us have a recap of this, and thereafter we'll delve into next slide. Just a moment. So the learning here on this slide is that Article 124 recognizes the existence of Supreme Court of India. Then Parliament does have power. I am again emphasizing that it is the parliamentary domain to increase the number of judges, and that provision is mentioned in Article 1. Parliament by law prescribes a larger number, right? Increase in number of judges of Supreme Court, High Court shall be decided not by the President but by the Parliament, right? That's why I keep placing this strike through, because in prelims there can be a trap, and this option can be given, right? And if you have not blown your mind with these, by placing these kind of options, right, by placing other options, right, you will surely make mistake. And that's why it is continuously suggested that do practice MCQ, do practice, because by when you will blow up your mind by these kind of questions, you will make sure that in prelims you will not do mistakes, right? So this was about existence of Supreme Court. We also have talked about Supreme Court genesis and historical perspective. Let us now start talking about that how the appointment process of Supreme Court judges and High Court judges have evolved over a period of time. And I am using this word evolved deliberately, because when you will see the appointment method, again I am saying that I am using the word appointment method, right? An appointment method of Supreme Court judges has gone through multiple phases, and here you do have these phases, right? So let me get off the screen so that you could see these things. I hope you would have seen this timeline. So initially you have this phase from 1950 to 1993, where method of appointment, whatever method of appointment, we'll study this, right? In Article 124, the process of appointment or the method of appointment has been mentioned. The same article which recognizes existence of Supreme Court, in the same article, right, the second clause of same article does have mention of process, that how Supreme Court judges are to be appointed, right? So Supreme Court judges will be appointed by using method mentioned in Article 124 until 1993, and after 1993 you will see that through a landmark judgment, that is second judge's case, you will see Collegium system will be evolved, right? Collegium system, and thereafter, means after 1993 until today, although there was a for around 3 or 4 months there was this body called NJAC, although there was no meeting of NJAC, and even means Parliament had just passed this Act 99th Amendment, Constitutional Amendment Act, through which this body came, right? So this body remained in existence for around 3 or 4 months, but it could not have any meeting, and finally Supreme Court struck down the validity of 99th Amendment Act. So had this body existed, right, in 2015, rather 2014, this body came into existence, right. So had this body existed, your collegium method would have gone, right. So the appointment would have been happening through this body or through this commission, that is called National Judicial Appointment Commission. But right now what we do have is that after 1993, the appointment of the Supreme Court judges and High Court judges is happening by this method called Collegium system, that was evolved by the judiciary itself in 1993, right. So I was talking about this, that Article 124, right, the appointment of the Supreme Court judges started happening by method mentioned in Article 124. Thereafter you have this first judges, all these judges cases means first judges cases, second judges case, what happened in second, then what happened in third judges case, then you have this fourth judges cases in 2015, right. So what has been the decision and how this evolution of method of appointment has happened over a period of time, we'll discuss all these things. So I just have given you a broad idea so that a structure could be made in your mind, right. So executive until 1993, so this is a landmark year and landmark judgment as well. So this is pre 1993 and this is post 1993 era, right. So as far as method of appointment is concerned, right, this 1993 year is going to be very important. Although these judges cases, first judges case, second, third judges cases and fourth judges cases are equally important, because this has given its observation, these judges cases has given its observation on this Article 124 or the method or the process that has been mentioned in Article 124. But this judge case, second judge case, is very important because it is by this judgment that you have this collegium system, right. So executive before pre 1993, you will notice when we'll discuss all these things, right, you will notice that executive had final say in the appointment of Supreme Court and High Court judges, appointment and transfer. When I am talking about transfer you will relate to the High Court, because Supreme Court judges transfer does not happen, right. So transfer, when I am talking about, it would be High Court judges. So executive, and when I am saying executive, you will notice that in Article 124, for appointment, the appointing authority is president, right. So president plus cabinet, because president does not do anything at his own, right. He is always driven by the aid and advice of what you call cabinet, right. So whenever I'll use the word, right, that president is appointing or president is doing anything in this chapter, as far as this chapter is concerned, you will refer that it is the government of the day or the cabinet, right, that is doing that, right. So until 1993, because of the words that has been mentioned in 124, right, you will see that the executive include president plus cabinet, right. So they had final say in the appointment of Supreme Court and High Court judges appointment and transfer. After this 1993, after this landmark judgment, right, this collegium system was judicially evolved or emerged, right. Now judges will be appointed by judges themselves, because collegium system that I am continuously repeatedly referring, right, those will have members from the judges itself, right. So for the Supreme Court judges appointment, right, the collegium that we do have is this CGI plus 4 senior most judge of Supreme Court, right. So those are nothing but judges themselves. So collegium system was judicially evolved, and now judges will be appointed by judges themselves. So this is the broad idea. Let us start delving into next slide, and let us start discussing that what is the process of appointment that has been mentioned in Article 124, and how abuse of this Article 124 will start in around 70 to 77. And if you remember, this is the period of Madam Gandhi, the same period in which this emergency was imposed, right. So Madam Gandhi is again going to be our villain for this chapter or for this appointment, because of it is because of Madam Gandhi that this collegium system, right, whatever acts that she did during this emergency and even pre-emergency, her acts like 24th Amendment, right. So you will have to relate this chapter from the chapter chapter that we discussed, amendment of Indian Constitution, then basic structure of Indian Constitution, and the third chapter that you will have to relate it with the acts that was done by Madam Gandhi during emergency. So whatever amendment that she brought, like 24th, 25th, 38th, 39th and 42nd amendment, right? So the emergence of Collegium is largely because of this amendment, the continuous executive and judiciary tussle that we'll see, right? The emergence of Collegium system is means from my assessment, right, it is these amendments that compelled judiciary to evolve their own system of appointment. Let us start discussing that what is mentioned in Article 124, and thereafter we'll see. So right now the conclusion is that the appointment that we are going to study in Article 124, the appointment method, right, today that appointment method does not exist, right? What we do have is Collegium system, judicially evolved Collegium system, by which appointment of Supreme Court judges does happen. So let us start discussing these things one by one, this evolution one by one. So here you do have Article 124, right? So Article 124, the first clause we saw that it was dealing with the existence of Supreme Court and number of judges that Supreme Court will have. Then the second clause of Article 124, right? It says that every judge of the Supreme Court, so it is declaring that who will appoint Supreme Court judge, right? So every judge of Supreme Court shall be appointed by President, right? So the appointing authority of Supreme Court judges is President by warrant under his hand and seal. What is the meaning of by warrant under his hand and seal? This meaning we already have understood when we were discussing the President's power, but let us repeat it. So there are only few employment letters that is signed directly by the President, right? And it is including CAG, right, including the Supreme Court judges and High Court judges, right? It is only these people whose appointment is directly signed or whose employment letter is directly signed by the President, and the meaning of this is this, that the warrant under his hand and seal, right? Then means appointing authority of judges is President. Thereafter these two clauses or sub clauses of Article 124 will discuss what will be the process of appointment of Supreme Court judges. So President to appoint Supreme Court judge after consultation with such judges of Supreme Court and High Court as the President may deem necessary. Let us read it again. President to appoint Supreme Court judges after consultation with such judges of Supreme Court. So while appointing judge in Supreme Court, right, he may, the word has been used as that may deem necessary, right? So he may consult judges of Supreme Court, judges of Supreme Court, judges of High Court, but it is not necessary. This consultation is not necessary because the word that has been used is that as the President may deem necessary, means if he does not, in his opinion, if it is not necessary, then he may skip this consultation from Supreme Court judges and High Court judges while appointing this Supreme Court judge. I hope this point you would have understood. Let us see the another sub clause. Provided that in case of appointment of judge other than Chief Justice, the Chief Justice of India shall always be consulted, right? So other judges, while appointing the judges of Supreme Court, he may not consult High Court judge, he may not consult any Supreme Court judge, but he will have to surely, the word is shall, then he will have to surely consult the Chief Justice of India, Chief Justice of Supreme Court, right? So while let me repeat it again, it may be confusing. While appointing Supreme Court judge, he may, means constitutional provision is that he may consult other judges of the Supreme Court, other judges of the High Court, but only if he feels that it is necessary. If he feels that it is not necessary to consult other judges of Supreme Court, other judges of High Court, then he means he is not bound to consult them as the President may deem necessary. and you will see that this provision is going to be abused, right? But the second sub clause again says that while appointing, means other judges it is not necessary, right? There are multiple in Supreme Court today. You have around 33 plus 1, that is the combination. Then you have in the various high courts, right? So he may not consult this 33 judge, right? He may not consult while appointment of Supreme Court. He may not consult these high court judges, right? But Chief Justice of India, that one number, Chief Justice of India shall always be consulted. I hope this is the process of appointment. Now, one thing that has to be noticed here, the word has been used as a Chief Justice shall, although the word is shall, that he shall always be consulted, but the meaning of this consulted has not been specified, right? Will this consultation just mean informing, for your information, that just inform the Chief Justice of India that this is the judge that we are going to elevate from High Court to the Supreme Court, right? So in Supreme Court 2 judges has to be appointed from Madras High Court, right? So Madras High Court does have pool of say 60 judges. I am taking a hypothetical example. So 2 judges from the Madras High Court has to be elevated to the Supreme Court. Now, as per this, if I follow the words that has been given or the spirit of this article, right, Chief Justice shall always be consulted, right? So if executive makes its mind, right, that 2 random judges has to be elevated to the Supreme Court, what is the meaning of this consultation? Just CJI will be just informed, or his concurrence is required, right? What if the word is concurrence? So what if the Chief Justice says that whatever 2 picks or 2 people that you have picked for the elevation, in my opinion, he is not fit for the appointment. So there will be conflict. Executive has picked up A and B, but Chief Justice of India is saying that these 2 people, A and B, is not fit, right? So in case of conflict, if there is any case of conflict between the choices of the executive or the president and the Chief Justice of India, what will be the situation? Whose opinion will be considered, or whose opinion will be put upon higher pedestal? Because it is not clearly mentioned that whether Chief Justice advice will be concurred or he has just to be informed, right? And this again, this word is also going to be played by the executive, means period of 50 to 70, you will notice 90-50 to 90-70, right? This will go easy, right? Whatever, means there will be harmony between Chief Justice of India and the executive. Whatever executive, means whatever Chief Justice of India will say, those judges will be elevated to the Supreme Court. Out of, I do have data, right? I was seeing the lecture of RM Lodha, Justice Lodha, right? So he had given some data, Justice Lodha, right? So he was saying something like this, that for first 10 years from 1950 to 1960, there were 210 elevation from various high court to the Supreme Court, and in those 210 elevations, right, 209 times Chief Justice of India's advice was considered. His advice was put on higher pedestal. Whatever advice Chief Justice of India gave about the elevation of the judges from the High Court to the Supreme Court, out of 210 elevation, 209 times Chief Justice of India's advice was concurred. His advice was taken into account, right? So there was no conflict. Come year 70 to 77, you will see mass transfer of High Court judges taking place. During emergency, whichsoever judge will not concur with the opinion of Madam Gandhi, that judge will be transferred. You will see there would be many Chief Justice of India. There would be 2 instances where Chief Justice of India's appointment method will be played with. We will see the instances, right? So the word, this consulted, is going to be played with. That is the emphasis of this slide, right? I hope this appointment method you would have understood. So this appointment method is in regard to the judge of the Supreme Court, right? Simple judge. As far as Chief Justice of India is concerned, how Chief Justice of India will be appointed, that has not been mentioned. Means Chief Justice of India of course will be appointed. So right now you have these 33 plus 1, right? That is the composition. Now you have this SA Bodhbe, right? He is the Chief Justice of India. Now when he'll go, when his term will expire, right? Out of these 33 people, out of these 33 judges, who will be appointed this Chief Justice of India, this has not been clearly mentioned in Indian Constitution, right? So a political convention developed, what is this? So shall always be consulted, right? No clarity in case of conflict between choice of CGI and president. So there is no clarity, that we already have discussed, that if there is any conflict between the choice of Chief Justice of India, if the Chief Justice of India is saying that A and B is not fit, and if they are of opinion that A and B is fit, what will happen, right? That is not clear. So that we already have discussed. Coming back to the Chief Justice of India, right? So who will be appointed Chief Justice of India? Out of this 33 people, right, that has not been mentioned in the Indian Constitution. And so you will see that a political convention developed in 1950 itself or 1951 itself, right, whereby it was said that whosoever out of these 33 people in the Supreme Court, whosoever will be senior most in terms of experience in Supreme Court, right, whosoever the senior most judge in terms of experience, he or she will be appointed Chief Justice of India. And that was rather a very good convention, because had this convention, see, in Constitution there is nothing mentioned, right, and if convention has also not developed, right, if there would, in absence of this constitutional mention and in absence of this convention, it would have led to something called arbitrariness, right, because president executive has to appoint, right, and this political executive all the time, right, although these people means until 50 to 60, right, rather 64, you have these first generation leaders, right, they had come from these independence movement and they had high political morals, right. So those people could have been believed, but after these 70s or even today, right, these political executive, you will see they cannot be believed, right. And in absence of constitutional mention and in absence of this political convention, right, it would have promoted something called arbitrariness, right. So they would, the political executive at any time can pick any of these 33 people and can make him CGI, right. And who will be picked in absence of, if they will follow this arbitrariness, any person, right, who is who shares the economic viewpoint, who shares their who is their loyalist, right, that person, he or she will be picked up and he or she will be made Chief Justice of Supreme Court. So finally in 1951 you will see that this political convention developed, and as per this political convention, whosoever person was senior most in terms of experience in Supreme Court, he or she will be appointed Chief Justice of India, although there hasn't been any case until this 70 plus years of judicial history that any she would have been appointed CGI, right. Practice developed, the senior most judge of Supreme Court began to be appointed as Chief Justice of India as president, by president, sorry, right. Now there has been deviation, and deviation has been in Madam Gandhi's age. However, this precedent of appointing senior most judge as Chief Justice of India was violated twice in 70s, Ain Ray in 1973 and M.U. Beg in 1977, right. You had in Ain Ray case, there were 3 senior most judges, 3 other senior, means apart from these his number was 4, he was 4th senior most judge, right, and he was made Chief Justice of India, right, means 3 people he superseded. And the only reason, see, he'll be appointed, means prior to this his appointment in Ain Ray case, right, you had this Keshwananda Bharti case, in 1973, and this Keshwananda Bharati case had evolved this basic structure doctrine, right? Madam Gandhi had done few amendment, 24th amendment and 25th amendment, right? And this judgment, Keshwananda Bharati case, you will see that this judgment was interfered with, right? And these people came up with this basic structure doctrine, right? And Madam Gandhi took this decision in the Keshwananda Bharati case with the evolution of this basic structure, right? She took it personally, this Keshwananda Bharati case, and there were few judges on this panel, right? And it is these three people, right? These three who were superseded, right? Those people were in this panel, right? Who led this judgment, whatever judgment that came in Keshwananda Bharati case, right? And it is alleged that these three people were punished because of the judgment that they gave in this case, right? So A.N. Ray in 1973 and M.U. Beg in 1977. In this case, in 1977, you will notice that H.R. Khanna, Hansraj Khanna, he was supposed to be, he was senior most judge, he was supposed to be elevated as or promoted as Chief Justice of India, but it is because of his two judgments. One, he was in panel of Keshwananda Bharati case in 1973, and during emergency, you will notice that there is something called ADM Jabalpur case. This ADM Jabalpur case is also called famously habeas corpus case. So if you have read habeas corpus case, so if you have read this Article 20 and Article 21, right, this does have mention of this ADM Jabalpur case. Right now I will not get into the details of this, what is this ADM Jabalpur case, but this did had relation with the right of life and right to personal liberty. So in ADM Jabalpur case, this Hansraj Khanna was the only person who gave the dissenting judgment, right? There was case, means political, various political politician from the opposition party, they had been jailed, right? And in ADM Jabalpur case, citing the right to life and right to personal liberty, right? This case had opposition party politician had filed the case for their release, that we do have also right to life, we do have right to personal liberty. But in ADM Jabalpur case, the judgment was given that no, during the emergency, state can take away right to life and right to personal liberty. Means during operationalization of this emergency, state does have right to take away this Article 20 and Article 21, right? Finally, you will see that in 44th amendment, means again I'm getting into detail of fundamental rights, right? So in 44th amendment, finally the amendment will be done, and it will be said that these Article 21 cannot be taken away even during emergency. So there were a few basic rights that you cannot take, right? So in this judgment, you will notice that H.R. Khanna, Hansraj Khanna was the only person, although the judgment, final judgment was that Article 20 and Article 21 can be taken by state during the emergency. And who had imposed the emergency? Madam Gandhi, right? The executive, sorry, I should not be naming. So executive has, so this judgment favored the executive, that executive can jail opposition member, executive can incarcerate them, right? And these high courts and Supreme Court will not come to the rescue. In this case, H.R. Khanna was the lone person, who had given the dissenting judgment, and his dissenting judgment was that Article 20 and Article 21 is sacrosanct, that cannot be taken by the state at any time, does not matter what the circumstances are, these two articles cannot be taken by the state. And it is because of this judgment that H.R. Khanna, you will see, will be denied this post of CJI, Chief Justice of India, in 1977. And in 1978, you will notice, right, he will resign from the Supreme Court, right? Although in 1978, when Janata government will come, right, he will be appointed law minister, but he does not join as a law minister as well. 3 days later, after being appointed law minister, he resigned from this law ministry as well. So that was a political story. Coming to this chapter, A.N. Ray case in 1973. So the political convention that had developed, that whosoever will be senior most judge, right, he or she will be appointed Chief Justice of India, right? That political convention was not followed in 70 twice, in 73 and in 77, right? You will notice that these people, A.N. Ray and M.U. Baig, was given preference in other judges in relation to the other judges. They were, means other judges' seniority was ignored, right? His appointment as Chief Justice of India was made after superseding 3 senior most judges, right? Reason of ignoring the Keshwanand Bharti case: H.R. Khanna, 1977. H.R. Khanna was replaced with M.U. Baig for Chief Justice of India. He was ignored because of his dissenting judgment in ADM Jabalpur case. And rather, this A.N. Ray, right, there is a story. Again, this is not substantiable, but in judicial circle there was a story that he was appointed because this person shared the economic and socialistic idea of Madam Gandhi, right? Her economic viewpoint. There were again stories that is in judicial circle that before every important judgment he would call Prime Minister's office, right? And similar story with M.U. Baig as well. Rather, in during emergency, Madam Gandhi had given call for something called committed judiciary, a judiciary which shares economic and social viewpoint of the political executive, right? In famous call of committed judiciary. However, principally this judiciary should never be committed, right? We do have something called separation of power. You do have 3 organs of state: legislature, executive and judiciary, right? Legislature legislates, executive implements, and judiciary has to adjudicate, right? If this judiciary, view of judiciary starts aligning with the executive, it will be catastrophic for any functioning democracy. Democracy cannot function, and it is because of these combination, because of our call of committed judiciary, because of our arbitrary attitude, right? That period of emergency has been called darkest history or a blot on democracy of India, right? So this was, means coming back again to this chapter, right? H.R. Khanna we already have read. So there has been this deviation. If you see another instance, there have been another instances in the same period, in period of, just a moment, in period of this 70 to 77, this is not the only deviation, right? About this supersession of A.N. Ray and M.U. Baig. This was not only what you call deviation. There has been deviation in other phases as far as in relation to judiciary as well, judiciary only, right? There has been other deviation in other areas as well. There has been cases of what you call mass transfer of High Court judges in this era, 71 to 77. Just a moment. Article 124 provided that in case of appointment of judge other than Chief Justice, the Chief Justice of India shall always be consulted. Now, we already have discussed that the meaning was not clear. What is the meaning of consulted? Now, in this era, means I had discussed already that during 50 to 60, when I was taking the example that out of 210 elevation into the Supreme Court, right, from the High Court to the Supreme Court, right, how does Supreme Court judges are appointed? They come from this High Court. So, in case of elevation from High Court to Supreme Court in 50 to 60 era, out of 210 appointment, 209 times, right, Chief Justice views were considered, not considered, rather concurred. I hope you don't know meaning of concur, right? So, but in this era, 71 to 77, the meaning was completely twisted, and now the meaning will become that for your information, means he will be provided, Chief Justice of India will be ignored at many times, and he will just be provided for fulfilling this formality. He will be provided the information that we are going to appoint him or her, we are going to transfer this High Court judge from this High Court to that High Court, because in Constitution the meaning is not specific. So, age of 71 to 77 was the time of executive judiciary tussle, right? This we have already studied in basic structure when we were discussing. So, executive judiciary tussle in this era, that how executive was coming with the amendment, whenever judiciary was coming with any kind of judgment which was taking away or seemingly or remotely taking away the powers of the executive, or was even interfering with the powers of executive of legislature, right, you will see that executive will come up with some amendment. And these amendments were nothing. 24th, 25th, 38th, 39th amendments were nothing. When you will see these amendments, you will notice that this has been in backdrop of any judgment by the Supreme Court. So this 38th, 39th amendment were in judgment, was in backdrop of judgment of Allahabad High Court, right? This 24th, 25th judgment again was in backdrop of a Supreme Court case, right? So all these cases has already been discussed in the basic structure chapter that we were discussing. So I'm not getting into the detail, right? Executive judiciary tussle as well has been discussed there in detail, right? So this age of 71 to 77 was time of executive and judiciary tussle, right? Word consulted was most abused. This word consulted was most abused, and CJI, Chief Justice of India, was just informed in case of mass transfer of judges from one high court to another high court. And why this mass transfer of judges was taking place? Because see, in 69 what had happened? This Congress was separated. Congress was divided into, if you know, right, the post-independent history, political history, Congress was divided into Congress I and Congress O. Congress O means old guard of the Congress, and Congress I, Madam Gandhi's Congress, right? So she had to develop a brand of herself. So she developed a socialistic brand of herself, right? Pro-poor brand. And now, to be pro-poor, she had to amend this DPSP. And to amend this DPSP, she also had to ignore certain fundamental rights. She had to take away fundamental, while bringing the legislation, right? Few fundamental rights had to be taken away, like Article 14, Article 19, right? And whenever she will bring any such law which violate this Article 14 and Article 19, judiciary will come to the rescue, right? And judiciary will often strike down the legislation that she will bring, right? So ultimately you will see that whosoever, means whichsoever judiciary from High Court or Supreme Court, whosoever judge is not concurring with the view that she is professing, right, there will be transfers, right? Sarkari judges being appointed, and this is not my word, this Sarkari judges being appointment, this is in judicial circles, right? Executive assertion in form of 24th, 25th, 38th, 39th amendment. In ADM Jabalpur case, habeas corpus case, HR Khanna, the lone dissenting judgment paid the price. So these are the cases of instances of abuse of this word consulted, right? Because this consulted become just providing information, just informing the CJI, not concurring with his views, right? We will simply inform him that we are transferring, that's all, right? So the transfer of these judges will take place, and this whole means along with these two deviation of ignorance of what you call deserving judges like HR Khanna and other judges, because of these two deviation in 73 and 77, coupled with these instances of mass transfer, Sarkari judges being appointed, they developed a mistrust between executive and judiciary, right? So whatever trust that executive or legislature had built during this 50 to 70, despite not clarity on this word, whatever trust that they had built during this period, right, you will see that trust will be broken in this period, right? So mistrust developed that this executive cannot be, and you will see that in 75 when imposition of emergency took place, again this trust will be broken up, right? Judiciary will start saying that this political executive cannot be trusted for democracy, right? If democracy has to survive, we cannot just believe in the wisdom of this political executive. In Shankari Prasad case, if you remember, when we were discussing this Shankari Prasad case, some fundamental right was taken away. But even when this fundamental right was being taken away or being amended, right, Shankari Prasad, believing the political wisdom of politics of that time, politicians of that time, said that okay, fundamental right can be taken away. Although finally in Keshavanand Bharati case it was established that this fundamental right is what you call sacrosanct and it cannot be taken away, right? although there have been other judgments as well in relation to the fundamental right. But what is what does this Sankari Prasad case in 1951 shows? That these people did have belief, means judiciary at that time in 50s or 60s or 70s rather, right, did have belief on political executive. They believed their decision, that whatever these politicians are doing, right, it is ultimately for the happiness, or it is ultimately for the benefit of masses, right. But that trust, you will see, that trust will be raised down by executive in this period of 77 or 71 to 77, right, and it is because of all these incidents. And final nail was this imposition of emergency, right. And you will see, when this trust will be broken, right, there will be protest by Supreme Court and High Court Bar Association, right, because ultimately, see, when you are doing these mass transfers, when you are superseding the senior judges and you are promoting the junior judges, right, you are playing with the independence of judiciary. And independence of judiciary in any functioning, if your democracy has to survive, independent judiciary is inevitable, right. Independent judiciary, and independent judiciary is also part of basic structure. It is sine qua non, right. If you have to strengthen the foundations of democracy, you will have to have this independent judiciary. There is no alternative of independent judiciary. So any democracy, right, if you are forming any country, and if you want that country to have democracy, you will have to provide this strength and independentness, right. So independent judiciary is part of basic structure. Today it does have strong and independent judiciary is sine qua non for the functioning of Indian democracy. And this act, the acts that we discussed, that was seen as invasion of executive into the judicial domain, erosion of judicial independence, right. All these things were nothing but executive was playing with the independence through threat of mass transfer, right. You are saying that, okay, you deliver the judgment as per my opinion, whatever economic idea or whatever socialistic envisioning I do have, right, you will start delivering the judgment on those lines, otherwise you will be transferred, otherwise you will be not promoted, right. So that is the thing that you are saying essentially. Such acts by the executive was being seen as interference in the independent functioning of the judiciary. Former CJI, Chief Justice of India, Muhammad Hatiullah, has also said that this was an attempt, means he was referring to this era of 71 to 77. This was an attempt of not creating forward looking judges, means executive was not looking to create this forward looking judges, but the judges looking forward, right. There is a difference, right. Forward looking judges, the upright judiciary, they are not upright judges, they were not looking for, they were looking for some judges who are looking forward for something, right, plum posting, right, plum transfers, right, to the plumes of office of Chief Justice, right. So this was a statement by former Chief Justice Muhammad Hatiullah about how this executive was acting during this time, this era. And when this debate will start, you will see that whatever appointment method by which executive was appointing these judges into executive. So what was the appointment method so far? President would appoint judges in Supreme Court and High Court. When we will discuss High Court, you will see that authority of President extends here as well. So President will appoint if he deems necessary. If he deems necessary, he will take opinion of other High Court judges and Supreme Court judges. The only caveat was that he needs to take Chief Justice consult. He just need to consult this Chief Justice. So this is what was envisioned in Article 124. But when you have these kind of things, these kind of thing, this mass transfer, these kind of threats by constitutional amendment, whenever their judgments are being overturned by whenever these judgments. So what happened in 38th, 39th amendment? Her candidature from as a MP, member of parliament, right, was denied, right? In 38th and 39th amendment, she was prime minister, and her candidature had been challenged from the Rai Bareli, perhaps she was member of parliament, right? So Allahabad High Court has given judgment, so that whatever means you became PM by using, sorry, member of parliament by using state machinery, because her opponent had filed a case against her in Allahabad case. So it was in this relation, right? So whenever there was any opposing judgment, right, in response to that you are coming with the amendment, right? So in response to all these activity, in response to all these activities, right, this ignorance, right, a distrust developed, and under this distrust you will see this debate will be generated that now our independence is being endangered, judiciary independence is being played with by judiciary, and you will see there would be cases coming up, right? So finally you will see that you will have this first judge. So somebody will go, means somebody, you will see that SP Gupta, a person named SP Gupta, he will finally approach the court in 1981, I guess, just correct it. So in 1981 you will have first judge's case, and opinion will be asked, right, that what is the meaning of this consulted, right? Please clarify it. Means in Supreme Court this case will land, right, and the clarification on this word will be asked, that what is the meaning of this consulted. Means the meaning of consulted is just informing, or does the opinion of CJI, Chief Justice of India, also has some value. Thereafter you will see, you will have second judge's case, some clarification will be sought in third judge's case as well. Then you will have in 2014 National Judicial Appointment Commission, and in fourth judge's case in 2000. We'll discuss this, right? So judiciary fought, just a moment. So judiciary fought for its independence and carved out institutional mechanism which secured it independence. So through these four judges cases, first, second, third and fourth, exclude this as of now, right, for this conclusion. So through these four judges cases, judiciary is going to do nothing. Judiciary is going to fight for its independence, and it is going to carve an institutional mechanism. And when I am saying institutional mechanism, I am talking about collegium system. So it will develop this collegium system through which it will protect its independence, right? So let us delve into next slide and let us start discussing these cases. And in all these cases the common thread will be that clarification on this particular word will be sought, right? So let us move to the next slide. So first cases, first judges cases, that is also called SP Gupta versus Union of India case in 1981 rather, right? And that is famously also called first judges case, right? So as I told that what does this consultation, right? So the clarification of this word consultation that has been used in article 124, right, that was sought. Does it mean concurrence? So in first judges case, judiciary said that no, this consultation does not mean concurrence, right? The consultation only means merely exchange of ideas. So president will simply inform, president for the appointment of Supreme Court, he will simply inform, or along with inform, he will simply say, oh, okay, fine, means we are going to appoint this judge so and so, and there will be exchange of idea, but it does not mean concurrence. So if in case of conflict of choices between president and CJI, if there is any conflict, it is president's opinion that is going to prevail, right, as per the judgment given in this SP Gupta. So they are shooting, means judiciary in this case, right, from judicial angle, if I say, they are shooting in their own foot, right? So they could have easily given this judgment that no, this means concurrence, right, and things would have come into the pocket of the CJI, right, from 1981 itself, but they gave this judgment that no, famously called SP Gupta case in 1982. SC ruled by majority of 4, by a very thin majority, that consultation does not mean concurrence. Just for information is enough. Process is mere exchange of idea, whether that person should be appointed or not, right? Whether which person should be appointed, what qualification that he or she holds, who is more fit, right? So mere exchange of idea, not concurrence. If there is any conflict, it is the executive again who will prevail, whose idea or whose opinion will prevail in case of conflict, right? So that was the judgment of in first judge's case, right? Ultimate power of accepting recommendation of CJI in regard to appointment lies with the executive. So ultimate power through this case still lied with the executive and law ministry plus PMO, and not judiciary. Why I am referring these bodies, law ministry and PMO, what is their role, we'll understand when we'll discuss something called memorandum of procedure, right? That how actually judges are appointed, right? Consultation, mere exchange of ideas. Until 1993, the meaning of consultation in Article 124 will remain just mere exchange of idea. After 1993, in 1993, as I told, that this is going to be a landmark judgment, right? Second judge's case, right? And in second judge's case, you will see the meaning of this consultation is going to change, right? So the position that remained in 1981, right, and until 1993, that in cases of conflict, it is the executive whose opinion will prevail, right? And in post 1993, consultation will become concurrent. So this is the first judge's cases. Let us move to the next slide and let us start discussing the second judge case. So this second judge case in 1993. So this second judge case in 1993, right? So there is an association called Advocate on Record Association, right? So they again filed what you call a case against Union of India, and again clarification on this word was sought, and this time you will see that by a majority of 7:2, judiciary is going to say enough is enough, right? Now consultation will mean our concurrence, right? So until we approve, does not matter, means you keep coming with the idea that this judge should be transferred, this judge should be elevated, does not matter, right? It is our idea, means Chief Justice idea, it is our person idea who will prevail, right? So consultation mean concurrence, right? So in case of conflict of opinion on matters of appointment, Chief Justice of India will have primacy over union governments or president's view, right? They developed, it is this system, right, that developed Collegium system, right? And then this Collegium is nothing but a body of few people, right? It is ultimately incumbent on Supreme Court itself that what will be the size of Collegium. So you will notice that in second judge's cases, right, the composition would be CJI plus 2 senior most judge as far as the Collegium of appointment of Supreme Court judges is concerned. So in second judge case, this size is going to be of 3 people, CJI plus 2. This will be expanded in third judge's case in 1998, and it will be made CJI plus 4. So emergence of Collegium system. So this here you need to remember, and this case, right? So emergence of Collegium system happened through this second judge's case. Not the CJI alone, but CJI should consult 2 senior most judges of Supreme Court before sending any recommendation to the union government or president or executive, whatever word that you may want to put, right? Generally it is sent to the law ministry, right? Law ministry. So whatever communication that does happen between judiciary and executive, that happens through this law ministry. So law ministry is nodal body. One more observation was given in second judge's case, and this observation was that in this case itself, Supreme Court ruled that senior most judge alone can be made Chief Justice of India. So the deviation that had happened in 1973 in Ain Ray case, and in 1977 you had this MU Beg, right? Their treatment happened through this observation in second judge case, right? In this case itself, Supreme Court ruled that Supreme Court so senior most judge alone can be made Chief Justice of India. So this was about the second judge case. Let us move to the next slide and let us discuss this third judge's case. So in 1998 again, and this case, the backdrop of this case is Article 143, and Article 143 we already have read, right? This is presidential power, and if president does have to seek any kind of opinion or any kind of legal opinion of president want, right, he can send that question if there is any matter, right, or any legislation, any matter or any legislation that has come up to the president, and president does not have legal idea that whether this is constitutional or this document I should sign or not, whether this is constitutional or not. In that case, president can send that fact or that law to the Supreme Court, and that power has been given to the president under Article 143, and Supreme Court will ultimately advise that whether that particular object, that particular law or that particular opinion is constitutional or not, right? So using this Article 143, presidential reference was sent to the SC, Supreme Court, in 1998, and president finally asked that what is the meaning of this consultation. Please clarify that what is the meaning of consultation that has been used in Article 124 we already have seen, and Article 217 में भी मतलब ये यूज है. Article 217 का रिलेशन हाई कोर्ट से है, मतलब हाई कोर्ट के जजेस की अपॉइंटमेंट के जिस तरह से we do have Article 124 which specify how the judges of Supreme Court will be appointed. Similarly, in High Court section we do have Article 217 which does have mention of appointment or the method of appointment of High Court judges. So this word consultation has been mentioned there, right, in Article 124 we already have seen, right? So president now sought clarification from the Supreme Court using this presidential reference under Article 143 that please tell me that what is the meaning of consultation. You already have driven the meaning, right? But I also want, means it was nothing but an attempt by the executive to put the pressure on judiciary that okay, if some moderation can be, means if any role can be, right now the appointment is happening, appointment is completely within the domain of judiciary, right? They are appointing using this collegium system. Just president is putting a rubber stamp that yes. So whatever recommendation that is being sent by this judiciary, right, Chief Justice and this collegium system, president is doing nothing. He is simply putting yes, that yes, he should be appointed, right? So here executive is doing by this presidential reference. This was nothing. Although the meaning, what is the point of asking the meaning again when the meaning has already been clarified in 1993? Right? So it was an indirect way of exerting pressure on judiciary by creating a narrative again that the collegium system that you have created, right, that collegium system give us space as well, right, give us that the space in decision making in the appointment of Supreme Court judges, right? So you will see that the clarification that the Supreme Court will say that yes, this consultation, again they reiterate their previous position, and they say that the consultation mean concurrence, right? But in this case, right, along with that giving the meaning that the consultation mean concurrence, right, along with that meaning they also says that the size of collegium we are expanding, right, and it was expanded to include 2 additional judges. So as I said in previous slide, right, the size of collegium is going to be CJI plus 4 senior most judge of Supreme Court, right? So collegium would now consist of CJI plus 4 senior most judges of Supreme Court. Other than appointment of Supreme Court and High Court, collegium also decided on the transfer of High Court judges, right? When we'll study this High Court judges, we'll see that, right? But I mean, the space that this executive was trying to create in the decision making on the appointment of Supreme Court, one space was given, means one relaxation was given through this third judge's case, and that relaxation was that the president can recommend return recommendation to the collegium at least once, right? So whatever recommendation this collegium is sending to the law ministry, if the executive is not satisfied, so suppose 6 names we have sent, right, 6 names for the transfer of for the judges of one High Court to another High Court, or 4 plus 2, so 4 for the transfer and 2 for the appointment, right, 2 for the elevation from High Court to the Supreme Court. Now, if law ministry or executive is not happy with any one of the name or any two of the name, what they can do is that they can send the recommendation back to the Collegium for the reconsideration for once. That is the only thing, right? But if this time as well Collegium reiterates, it does not changes its opinion and send again the same 4 or whatever name that it had recommended, right? This time the president or executive will not have any option, but they will have to put up or issue the appointment letters, right? So that was one relaxation that was given by the third judge's case. One learning here is that the Collegium and memorandum of procedure. What is this memorandum of procedure? So memorandum of procedure is nothing but an agreement that has been signed between, or that has been verbally agreed between judiciary and executive on the method of appointment, that how this initiation on the, so if any judge has to be transferred, how this process, a formal process will start, or if CJI, Chief Justice of India, has to be appointed, who will take initiative. Although it is well understood that the senior most judge will be appointed, right, but there is something called formal process, right? So how that formal process means, how files will start moving, how this file will move from Collegium to what you call a law ministry, then how it will go to PMO, right, and then how it will be forwarded to the president, right? So all this formal process is nothing but memorandum of procedure, right? So this Collegium and memorandum of procedure is judicially evolved process, right? And understanding between, and this is memorandum of procedure is nothing but understanding between legislature and executive, right? And these two things, Collegium and memorandum of procedure, is not mentioned in the Indian Constitution, right? It is still not mentioned in the Indian Constitution, right? So I hope this third judge's case you would have understood. So it was 1998, right? And thereafter a new debate will start, and this debate was accountability of judiciary. So why this debate on accountability start? Let us start understanding. So in 1993 you had this Collegium system, right? Emergence of Collegium system. Then the next year is 1998 when the size of Collegium is expanded, right? So here what is happening through this Collegium system, you have these judges appointing judges, right? Do you have any other institution where people themselves appointing themselves? Do you have MLAs appointing MLAs? Do you have MPs appointing MPs? No, right? Here executive, if you see the three organs of our state, executive, legislature and judiciary, right? So executive is accountable to whom? Executive is accountable to legislature. You do have various tools like question hour, tools like committees, tools like what you call motions, different motions, right? And finally you have people's court, right? At the end of 5 years they have to, means executive is ultimately what? At the state level, if I talk about, executive is MLA. At the central level, executive is member of parliament, right? If they are not functioning in a good way, apart besides the tool that we cited here, question hour, committee system, motions and no confidence motion, besides that, at the end of 5 years or in cases even before that, right, they'll have to go to the people's court and they'll have to seek the re-election. And if they have not performed well, if they have not been efficient, right, they will not be re-elected, right? What about the legislatures? Same case. Legislature is accountable. So executive, besides being executive, is not only accountable to this legislature and motion and voter only, he or she is also accountable to the judiciary as well, right? If he or she is bringing any act or any of their bylaws are against the constitutional practices, are not in line with the constitution, their acts can be violated by the can be abrogated by the judiciary, right? So they are, along with being accountable to the legislature, voter and then people, right, they are also accountable to the judiciary. What about the legislature? Similarly, if they are passing any of the act and if that is unconstitutional, that act can be invalidated, can be stricken, right? So legislature is also accountable to the judiciary. But what about this institution, this judiciary? Who these people are accountable to? Besides not being elected, right, they are unelected, right, and they are appointing themselves and they are not accountable to anybody as well, right. In name of functioning democracy or in name of this independence, you have become completely monolith, right. Although I am taking a harsh criticism, but these kind of arguments that you will see will be presented for this body, for this emergence of this body called NJAC, National Judicial Appointment Commission. So here judges are appointing judges. So you will see that these are the factors. Accountability is suffering here. There is no accountability. You will see there will be cases of inefficiency. We'll notice that, we'll see that, right. You will see promotion of nepotism. When there will be promotion of judges, when there will be elevation of judges from High Court to the Supreme Court, you will notice in few cases in the Collegium, there have been some relatives of these High Court judges that are being elevated to the Supreme Court. They are relatives, the judges of these High Court relative in the Collegium. And that had not been pointed by, means that is not a mere allegation, that has been well documented and that has been appointed by the Bar Association of different high courts, right. Rather government as well, I have put up the data as well, I have a newspaper cutting, right. So government in 2018, right, just to prove this case of nepotism, right. I hope you know the dictionary meaning of nepotism. If you don't know, just you can Google it, right. So in 2018, government, just to prove this case of nepotism, has given some proof as well, right. I'll show you the newspaper. So this system where judges are appointing judges, there is lack of accountability. It has promoted inefficiency. It has promoted nepotism in some cases. You will see cases of corruption will also rise. I can't be more direct than this, right. So corruption, nepotism, right. This is undemocratic as well, right. Undemocratic, this system, because you people, as I cited, that MLAs can't appoint themselves, MPs can't appoint themselves, a MP cannot appoint another MP. Similarly, a judge, only judge in the name of, means how this, what is the argument of evolution of this Collegium? The argument was their independence for those 7 or 8 years, right, during that emergency period and that leaders, particular leaders period, their independence was attacked. Right, independence in terms of appointment, independence in terms of transfer, but just in name of that 7 or 8 year period, you have created this monolith body, right, and that is creating these kind of problem. And then in this intervening, means from 1993, right, you have 2020 right now, and how much, 7 and 20, right, 27 years, right. This debate has taken completely new turn, right. So let us see, we'll see all the points. So executive is accountable to the legislature, voter, and then judiciary too. Legislatures are accountable to voter and judiciary. Who the judiciary is accountable to? Virtually none, right. And in absence of this accountability, you will see these cases rising up. Judges are appointing judges, right. Opaqueness in the system of appointment. What is this opaqueness? Let us understand it. So suppose in Supreme Court, in a particular month, or for say 2 vacancy is going to be created, right, 2 months down the line. Now you have various high courts, High Court Madras, High Court Chandigarh, High Court Delhi, right. So you have various high courts, right. So suppose there are 60 eligible candidates. Now out of this 60 people, 2 will be elevated to the Supreme Court. Now 58 will be rejected. Now why these 58, why these 2 has been selected, and why this 58's candidature has been rejected, although they were similarly, when I am saying that they were eligible, I am saying that they were similarly placed, right, in terms of merit and in terms of seniority. Suppose all are similarly placed, so why 58's candidature has been rejected? That is not publicized, and that is nothing but promotion of opaqueness, lack of transparency. So apart from whatever inefficiency, corruption, nepotism, undemocratic, right, you can add another word, that is the ills of collegium system, right? That is opaqueness. Reason for acceptance of candidate rejection or deserving candidate is not publicized, right? And it is in this regard that the Justice Kurian Joseph, previous Justice Kurian Joseph, castigating collegium system, he said that many deserving judges were ignored and non-meritorious were appointed by this system, right? Why ignored? Why these people, 58 people have been ignored, right? Those reasons are not publicized, right? And that's why this debate between independence and credibility, because if you have these many ills, if any system is promoting corruption, if any system is promoting nepotism, if any system has promoted opaqueness, on this front of opaqueness, there was period of 2 to 3 years where a particular CJI Chief Justice of India had started this system where on website of Supreme Court, right, whosoever has been selected, right, there, and whosoever has been rejected, right, the reason of their selection had been publicized. But in 2015 or 2016, I am not sure, right, this practice was also, means this practice ran for only 2-3 years, right, and another CGI, perhaps Ranjan Gogoi, I guess, right, so he had scuttled away this practice as well, right. So that was on the front of opaqueness, right. So when you have these kind of ills, corruption, nepotism, right, so ultimately it will erode the credibility of that institution, right. So you had started that system, collegium system, for your independence, but now what you are doing, what that system or that institution is doing, that it is eroding your credibility, right. So that's the debate between that, what is, means to what extent our independence is required and to what extent credibility is required. And from my opinion, it is this factor at this moment, right, after passes of this 27 years of the emergence of this collegium system, right, judiciary must concentrate on this credibility, because this is the only institution that people or we as citizens look up to, right. And if the credibility is not preserved, at least of this institution, right, people have lost faith in legislature, people have no hope in the executive, right. You know how politically vitiated environment we are living in, right. So this is the only institution, judiciary, we look up to, and if their credibility is not preserved, I don't know where we'll go, right. So collegium system has eroded credibility of judiciary because of all the ills, right. So in 2018, if you see, 2018 or yes, 2018, government gives collegium proof of nepotism in picks for High Court judges, right. In a rare move, government has mentioned relations of candidate with those retired judges or those in, there have been instances where, as I cited, right, in collegium, who is responsible for selecting the judges, right. So in the available pool of the judges who are eligible, right, collegium had relationship from a few of the people in this available pool of the judges, right. There have been cases, and that has been cited none other than the Bar Council itself, right. So that is the point. So this was the debate, right, and this debate, judicial undemocratic, we already have studied, right. Supreme Court has violated its own guidelines by ignoring seniority principle multiple times without any public explanation. This is called without any public explanation. This is called opaqueness, right. Undemocratic, they are appointing themselves, accountability to none, right. On matter of principle, if you see, by creating exclusivity, what is this exclusivity? Means you are giving space in decision making while selecting the judges, right. You are giving no role to the executive or legislature. So that is executive, that is exclusivity, right. So by creating this exclusivity in appointment of judges, judiciary destroyed checks and balances, right. So the checks and balances that I was talking about in the previous slide, if you remember, right, here executive if executive is doing something wrong, right, there are various tools available at the disposal of legislature through which it can check it, right. You have no confidence motion, you have censure motion, you do have that various, in budgetary front you have this cut motion, right, you have this adjournment motion, right. So there are various checks and balances. If legislature is doing anything wrong, if they are bringing any unconstitutional act, judiciary does have right that they can strike out that act, right. So this is nothing but checks and balances. But as far as judiciary is concerned, right, except impeachment, and impeachment, mind you, when we will discuss impeachment, you will see is a very difficult process, and it is owing to the difficulty that is in impeachment, right. You need special majority for the impeaching, and it is owing to this difficult impeachment process, you will see that none of the judges in a judicial history of the 70 plus years, none of the judge has been impeached so far, right. So that is the only check that legislature or executive does have over the judiciary. So they do have checks on each others. This judiciary is checking on the actions of these two, right, but this body, this particular body does not have, and that is the statement that was there in that slide, that by creating the exclusivity in matter of appointment, judiciary destroyed these checks and balances which is necessary for the separation of power, right. Independence should not mean accountability to none, right, because right now you are accountable to none, and this whole fight of the for the collegium system, right, happened for the independence. So independence should not mean accountability to none. And finally you will see that in NDA government will create this commission, M.N. Venkachalaya commission, around 2002, right, and it will submit its report in 2003, right. So along with this, committee had not been created directly for overhaul or for the reform in judiciary, to suggest reform in judiciary, but it had been created to review the working of the constitution, right. So along with the other recommendation in relation to the judiciary as well, it gave one recommendation, and that recommendation was for the creation of Judicial Appointment Commission, Judicial Appointment Commission, JAC. In 2003 it recommended. Finally you will see that in 2013 Congress government, UPA 2 comes up with a bill, NJAC, right. Perhaps it was 120th constitutional amendment bill, but in 2014 because Lok Sabha was dissolved, right, so this bill lapsed. Finally in 2014 you will notice that this new Modi government, right, they will come up with 120th constitutional amendment bill for creation of this body called NJAC, National Judicial Appointment Commission, right, and this body will be created, means this bill will be passed, and this will be called 19th constitutional amendment, and this bill will be passed in 2014 itself. But this body could not function because as soon this bill was passed, right, association of courts, perhaps one of the body, means you can generally take bar association, filed case for the to check the constitutionality of this act, because again it was, when we will see the composition of this body, you will notice that there are chances that a political person can land on this body, right. So this bar council, citing that reason that this body NJAC, here it will have one or two political people, right. So this will nothing, this body will do nothing if this body is allowed to select people of judiciary, right, that this will endanger our independence, right. So in 2014 the constitutionality was challenged, and in 2015, right, you will notice without having even a single meeting, right, judiciary itself strikes down this body called NJAC, and finally we are back to the collegium system, right. Let us see this. So 2014 constitution was amended and National Judicial Appointment Commission a 6-member body, mind you, 6-member body was created to replace this system and appoint judges in Supreme Court, High Court and transfer. So the role of this NJAC was appointment of Supreme Court judges, appointment of High Court judges and transfer of High Court judges. So that was the role. What was the composition of this body? So as I already told you that this was a 6-member body. So Chief Justice of India was supposed to be chairperson of that body. He was supposed to be the head of body. Along with Chief Justice, 2 senior most judge of Supreme Court. So almost like Collegium, right? So 3 people from Supreme Court, 4th people is from Law Ministry, Law Minister, Law and Justice Minister. He will be 4th person, and 2 eminent person who do have knowledge of law, right, to be selected by a committee. So these 2 eminent person, right, and doubt will be raised here, right, to be selected by a committee comprising Chief Justice. So the committee who will select this 2 eminent person, that will be a 3-body committee, and it will comprise Chief Justice of India plus Prime Minister plus leader of opposition. So this 3-member body will select this 2 eminent person. One condition, one eligibility criteria for this 2 eminent person was that they need to have background of law, right, law or jurisprudence. So that was the only condition, that these 2 members need to be fulfilled, right. Now the question will be raised. See, this is a 6-member body, has been created by 99th Amendment Act, and the role we already have discussed, right. So the bone of contention was about this 2-member body, right. You already have 3 members, 3 people from the judiciary. The 4th is Law Minister, Law and Justice Minister, and these 2 people. Now the contention of the judiciary was that these 2 people can be from political background. But the thing that judiciary forgot to, or the judiciary perhaps intentionally ignored, was that if you see the composition of this selection panel, right, you have this CGI, you have this Prime Minister. Okay, you can say that a particular Prime Minister may be politically biased, so he may recommend a person, right, who is biased towards his political party. But what about this? If he is bringing, if the Prime Minister is proposing any person for this 2 eminent person, would this LOP, leader of opposition, accept it? You have leader of opposition. Try to imagine the current situation. You have this Adhir Ranjan Chaudhary, right? You have Prime Minister Narendra Modi. Now suppose I take that, suppose candidature, for the candidature Ravi Shankar Prasad is being considered, right, for this what you call this NJAC, right. One of the person is Ravi Shankar Prasad, because he does have that eligibility criteria. He is from law and he does have knowledge of this jurisprudence, right. So Ravi Shankar Prasad, who is currently Law Minister, but we are taking a hypothetical case because I have to make this person political. So suppose Ravi Shankar Prasad's candidature is to be considered. So Prime Minister will propose, right. Out of these 3 people, if 2 people concur, then his candidature will be considered. But do you really think that leader of opposition, that is Adhir Ranjan Chaudhary, will approve? CGI is never going to. He'll straight away say that he happens to be political person, and if I include him or her in the panel, right, he is means our independence will be compromised, right. So CGI will directly say no for his candidature. But do you really think that Adhir Ranjan Chaudhary will say yes? No. Right. So only PM will propose, and this offer will. So unless, my point is that unless this person who is being considered for this 2 eminent person, unless he is apolitical, or unless he is so neutral that it is agreeable to both these people, right, his candidature will not be approved for the NJAC. So this body is ultimately going to be neutral, right. Even if, suppose, take an extreme case, suppose out of 2 eminent person there is 1 political person, let us take it, right, 1 political person, who was agreeable to this prime minister as well, or leader of opposition as well, means that person was not that political, right, and his candidature was approved by PM as well and leader of. So suppose extreme cases that out of these 6 people that you do have, you have one political person that came through this route. Still you have 5 other, and take law minister, he is anyway political, right? So the voting will be 4:2, right? Still whatever candidate that you are proposing, even in that case, even in the case where you have 2 people, one law minister and one from the eminent person, you have 2 people having political leanings, even in that case, whatever proposal that they will bring, right, that will be defeated, because that side will have only 2 numbers, 2 vote, one from this eminent person and one from law background, right? So from 4:2, right, the proposal that has been brought by this person, that will be defeated. So there was no reason, means again from my assessment, there was no reason for discardment of this body called NJAC, because if had this been in case, the previous argument about this exclusivity, right, would have been done away with, and this would have brought more credibility to the institution of judiciary, right? You could have claimed, as a judiciary, you could have claimed that now we are, means judges are not appointing judges, right? There has been an intense debate hosted by Arnab, right, in 2015 itself, when he used to be very peaceful and calm host, right? So on one side you had this RM Lodha, and the other side you have the then law minister late Arun Jaitley, right, and there were other people. So 2:2 members were there, and there was intense debate on the applicability of NJAC, whether NJAC is a constitutional body or unconstitutional body. There was intense debate. This is a 2-hour debate, right? You can see, you can simply type, if anybody does have from the law background, right, and if they does have interest that why this NJAC, what were the argument of judiciary for discarding, because here we do have limited time, so we cannot discuss all the aspect. But if anybody does have interest, right, you can type just in YouTube NJAC debate and Times Now. You can, means earlier, right now he is running this Republic TV, but then he used to be in Times Now. So NJAC debate, Times Now, and you will have the result from 2015, right? So this was ultimately, you will see that in 4th judges cases in 2015, this body will be invalidated. 99th constitutional amendment was declared illegal, and NJAC was declared unconstitutional by saying, by giving this point that it is going to endanger our what you call independence, right? We are back to the collegium system. Let us move to the next slide. So this was the 4th judges cases, right? This has not perhaps been mentioned in Lakshmikant, rather it is mentioned in the Lakshmikant, right? So the next we are going to do is memorandum of procedure. Let me remove it from here. So this memorandum of procedure is nothing, it is a verbally agreed agreement between executive and judiciary as to how this formal process of appointment take place, right? So if any Supreme Court judge has to be appointed from any of the High Court, this is the flow chart for this, right? So first, Supreme Court Chief Justice of India initiates the proposal after consulting the collegium. So collegium size is CGI, Chief Justice plus 4 members. So he'll consult, he'll have the candidature from the High Court judges. So suppose there are 60 or 50 eligible candidates, those 50, their background checks will be done, their eligibility criteria, their merit. So on all the factors they'll be accounted, and thereafter their candidature, means suppose 2 people has been selected, so their 2 people's candidature will be sent to the law ministry. That file will be sent to the law ministry. CGI should also seek opinion of Chief Justice also. This is one new point. So suppose from Madras High Court, just a moment. So suppose from Madras High Court one judge has been selected for the Supreme Court, then Madras Chief Justice opinion about that particular judge can also be taken, right? So CGI should also seek opinion of Chief Justice of High Court, from which Chief Justice has to be elevated. Here one point also I can add is that central government as well, central government or executive, if I say, right, if they do have certain name, they can also forward their names to this collegium for the consideration, right. Ultimately the decision of this collegium will prevail, even if they do not consider, center cannot raise any kind of objection. So once the name has been selected, that names recommendations are forwarded to the law ministry. Law ministry does have that simple job. They will just as part of this legal check, they'll involve this INB, Intelligence Bureau, and they'll ask that, okay, do some legal check. After legal verification, law ministry can once send the name back to the collegium for the reconsideration. Okay, so if executive or prime minister office does have any kind of reservation about any names that has been forwarded by this collegium, if you remember the third judge's cases, in third judge's cases, right, judiciary had given this scope that if in the opinion of executive, if any candidate is unfit that has been forwarded by the collegium, right, this executive can send the file for the reconsideration once to the collegium, but does not matter whether collegium reconsiders their opinion or not. If they forward the same name, the law ministry or the executive will have no option in that case, right. Collegium can ignore the law ministry's advice. For after this law ministry has considered that file, right, they will send it to the PMO. PMO finally will send this file to the president, and president will issue the appointment letters, right. So this was about, just a moment, of the judge, right, not CGI, right. CGI appointment method, we do have a different flow chart, right. So that person will be issued that appointment letter. So this was about a normal judge, right. If I talk about Supreme Court judge, how Supreme Court judge is appointed, so the process is, we already know, right, senior most person, right, who will be appointed, we already know that senior most judge will be appointed, but how? There would be some formal process. So first the law ministry will ask Chief Justice of incumbent Chief Justice or outgoing Chief Justice of India to send the name, right. So already everybody know that who is going to be appointed the Supreme Court Chief Justice of India, right, but the formal process, right. So incumbent or the outgoing Chief Justice of India, right, recommends the name of senior most judge, right. It is to be proposed by the outgoing judge. Thereafter file goes to the law ministry, which is shared with the PM, right. Here in this case no option to return, then shared with the PM, then PM shares files with the president, and finally president will appoint that person as Chief Justice of India. So this is nothing, this flow chart is nothing, memorandum of procedure. And one caveat is that this memorandum of procedure that we just discussed, this memorandum of procedure was being followed before this NJAC, right. After the abolition of this NJAC, a new memorandum of procedure is being negotiated between judiciary and executive. Until this new memorandum of procedure has been negotiated, this process will be followed, right. That there are some hurdles, the new memorandum of procedure that executive had forwarded, there are certain provision that is not agreeable to judiciary, and that's why that is pending. So until that new memorandum of procedure is agreed, you have this process that is being followed, right. So with this we are wrapping up this lecture. This has already been very lengthy. Now you do have few MCQs. So here you do have first MCQ, second MCQ, third MCQ, and fourth MCQ, sorry, third MCQ, right. So with this we are wrapping up this lecture. In the next video we will discuss term, qualification, tenure and other things, power, functions, right. So till then, bye bye.